I received this letter 3 days ago. It was written on the back of a commissary request form by a man named Tariq. He's sitting in a county jail right now, waiting for a bail hearing because of what happened when he took an Uber home from his night shift. He asked me to read it to you. So I'm going to do exactly that. And as I read, I'm going to pause and tell you the law that Tariq didn't know, the law that would have kept him out of that cell. The letter starts like this. Dear Mr. Cole, I'm writing because I don't understand how I ended up here. I was just a passenger. I didn't do anything wrong. It was 2 a.m. I ordered an Uber from the warehouse where I work. I was tired. I got in the back seat, put my headphones in, and we drove off. 5 minutes later, the driver got pulled over. The officer said his rear brake light was out. I didn't think much of it. But then the officer shined his flashlight into the back seat, right in my face, and said, "You. I need to see your ID. And while you're at it, hand me your phone." Tariq's letter stops there for a second, and you can see the confusion on the page. He wrote, I thought I had to. I thought passengers had no rights, and that's the first mistake that trapped him. So let's pause right here. A rideshare is still a car. When that car is pulled over, the stop is a seizure of the driver. But what about the passenger? In the 2007 Supreme Court case Brendlin versus California, the court ruled in that a passenger is also seized during a traffic stop. That means the police can't just randomly demand things from you without a legal reason. The stop itself is temporary, and the officer can ask for the driver's license, registration, and insurance. But you, as a passenger, are not automatically required to produce ID, unless the officer has independent, reasonable suspicion that you are involved in criminal activity. You have the right to remain silent beyond, at most, identifying yourself in states with stop and identify laws. And here's what Tariq did next. He handed over his driver's license and his unlocked phone. The officer walked back to his patrol car and was gone for 20 minutes. While the officer was gone, the Uber driver sat frozen, staring at the rearview mirror. Tariq wrote, I kept thinking, maybe he'll just give me a ticket and let us go. I didn't know I could ask to leave. I didn't know I could just get out. That brings me to the second legal thread that unraveled his night. Under the case Arizona versus Johnson, an officer can order a passenger out of the car during a stop for officer safety. But that's not what happened here. The officer never asked Tariq to step out. Instead, he prolonged the stop well beyond the time it takes to write a warning for a brake light. In Rodriguez versus United States, the Supreme Court said an officer cannot extend a traffic stop to conduct unrelated investigations without independent, reasonable suspicion. Tariq's ID had no connection to the brake light. The officer was fishing, and when he came back, he had found something. Tariq's phone revealed a group chat where a friend had joked, "If the cops pull you over, tell them you're my lawyer." It was a stupid joke. But the officer used it as evidence that Tariq was impersonating an attorney, which is a felony in that state. Tariq was arrested on the spot. Let me read the next part of his letter, because this is where the pain seeps through the paper. They pulled me out of the car and cuffed me. I said, "What did I do?" The officer said, "You'll find out." They took my phone, my wallet, everything. I spent the night in a holding cell. My Uber driver just drove away. I kept thinking, I was just trying to get home. How is this legal? The answer is, it wasn't legal, Zarim. But it happened because he handed over his phone and his ID without ever asking a single question about his own detention. The law gave him a shield, but he never lifted it. Now, I want to show you the exact moment that could have changed everything. The officer said, "You, I need to see your ID." Instead of fumbling for his wallet, Zaid could have calmly said, "Officer, am I being detained or am I free to go?" That question forces the officer to state whether Tariq was the subject of an investigation. If the officer had no reasonable suspicion, Tariq was free to leave the car and walk away. Even if he was detained, he was not required to unlock his phone. The Supreme Court in Riley versus California made it crystal clear police need a warrant to search the digital contents of a phone, even after an arrest. And that includes a passenger in a rideshare. The only exception is consent. Tariq handed over the phone and unlocked it. That's consent. And under Schneckloth versus Bustamante, the police don't have to tell you that you can refuse. So in that moment, the officer didn't need a warrant. He had Tariq's thumb on the sensor and his permission in the air. But let me take this letter and fold it differently. Let me read you a version that I wish had been written. Imagine Tariq. Same car, same brake light, same flashlight. The officer says, "You. I need to see your ID." Tariq looks up, hands still on his lap, and says, "Officer, am I being detained?" The officer pauses. "Just give me your ID." Tariq repeats, "Am I free to go or am I being detained?" The officer hasn't answered, but now Tariq has put the law on his side. If the officer says he's not detained, Tariq can open the door and walk away. If the officer says he is detained, Tariq immediately invokes his rights. "I am exercising my right to remain silent. I do not consent to any searches. I want a lawyer." And then he says nothing else. His phone stays locked in his pocket. The officer, with no probable cause and no consent, has no legal basis to search it. The stop ends with Tariq walking home, hands-free. Now, you might be thinking, but what about state laws that require me to identify myself? Let's address that. About 24 states have stop and identify laws. In those states, if an officer has reasonable suspicion that you're involved in a crime, you must provide your name. Some may also require an address or date of birth. But the key is that the officer must have reasonable suspicion first. And you are not required to hand over a physical ID if you don't have one, nor are you required to answer any other questions. In states without such laws, like California or New York, you don't even have to give your name.
Unless you're driving.
So, a passenger in the back of a rideshare has even fewer obligations. The police can ask for ID, but you can politely decline, ask if you're free to go, and remain silent. But what about the driver? The Uber driver in Tariq's story was also scared. He might have felt compelled to hand over his own phone or allow a search. That's a separate issue. But as a passenger, you are not responsible for the driver's choices, and you can assert your own rights independently. If the officer orders you out of the car, you must comply. But you don't consent to a search. You simply step out, keep your hands visible, and repeat, "I do not consent to any searches." Let's shift to a related scenario, because rideshares aren't the only place this happens. Imagine you're on a Greyhound bus. Federal agents board the bus at a stop and start asking passengers for ID and phones. Can they do that? The law here is more complicated because Border Patrol and federal agents have different powers within 100 miles of the border, but the basic principle remains. You have the right to remain silent, and you do not have to consent to a phone search. In United States versus Drayton, the Supreme Court said that police don't have to inform bus passengers that they can refuse consent, but they also can't coerce it. So, if an agent blocks the aisle and demands your phone, you can say, "Am I free to go? I do not consent." If they continue, any evidence found may be suppressed. What about a taxi? Same rule. You're in a cab, police pull it over, they want to search your bag or your phone. You're still a passenger. still protected by the Fourth Amendment. You don't lose your rights just because you're in a vehicle you didn't drive. The Brenlin ruling applies just as much to a yellow cab as to an Uber. Now, let's go back to Tariq's letter. The last page is the hardest to read. He wrote, "I lost my job because I missed 3 shifts while I was in jail. My family doesn't understand what happened. I keep replaying that moment in my head. If I had just said one sentence, maybe I'd be home right now." That sentence exists. It's not complicated. It's, am I being detained or am I free to go? I do not consent to any searches. Those 2 sentences are your firewall. They don't require a law degree. They require practice. So say them out loud with me right now, wherever you are. Am I being detained or am I free to go? And I do not consent to any searches. Those words are yours. Nobody can take them away. I'm going to leave Tariq's letter on my desk and speak directly to you now. The system counts on your silence. It counts on your fear. It counts on you not knowing that a passenger in a rideshare has the same constitutional backbone as a person standing on the steps of the Supreme Court. The next time you get into an Uber after a late shift or a taxi after a party, remember Tariq. Remember that the flashlight in your face is not a command. It's a question that you have the right to answer with another question, and that question can set you free. If you want to know what to do if the police come to your door instead of your rideshare window, the next video on your screen walks you through the exact script for a knock and talk. It's a different scene, but the words are just as powerful. I'll see you there.